thank you all for being here today. It's so great to see so many faces in the room, and hello to all of you joining us online. For those of you that don't know me, my name is Isabel Hahn, and I work in the cabinet of the European Data Protection Supervisor. And I have had the honor this year of being part of the organization team for this conference. I also have the honor this morning of moderating the first main session today, which will aim to set the scene for the discussions over the next couple of days. When the EDPS conference was first announced, we promised to bring together stakeholders from different fields of law in order to discuss not only different governance models, but also approaches to enforcement more generally. We hoped to create a dialogue on what it is that we want and how it is we can get there. Today, with this first main session, we aim to begin delivering on that promise. This session, titled "What Does Effective Enforcement Mean?" will aim to discuss what it is that we mean when we speak of effective enforcement. Do we have common standards by which we judge whether enforcement is effective? Is there a common consensus around whether enforcement is working? If so, what is this benchmark and how is it set? What could we do better, and is there anything that's holding us back? For this discussion, we bring together 4 individuals who no doubt you are familiar with given their leading roles. On this note, please join me in welcoming them to the stage. Thank you all. By way of quick introduction, please allow me to introduce the speakers briefly, although I'm sure you've seen their faces before. So, in no particular order, we have with us today Max Schrems, founder of noyb, European Center for Digital Rights, which deals with pan-European data protection litigation. Max also has 1 or 2 cases from the European Court of Justice named after him, which you may or may not be familiar with. We also have the pleasure of welcoming Ursula Pachl, Deputy Director General of BEUC, the European Consumer Organization, which represents 46 independent national consumer associations from 32 European countries. Ursula leads BEUC's work on digital policies, consumer rights, redress and enforcement, and is responsible for horizontal and strategic policy, such as EU governance. We also have with us Mr. Ulrich Kelber, Germany's Federal Commissioner for Data Protection and Freedom Information, whose office is directly competent for supervising federal government authorities, private telecom, postal services, and he also serves as a joint representative of the German data protections before the European Data Protection Board. Last but definitely not least, we have Mr. Paul Nemitz, Principal Advisor in the Directorate General for Justice and Consumers of the European Commission. Mr. Nemitz has represented the European Commission in numerous cases before the European Court of Justice and has published widely also on EU law. So to kick off the discussion, let me perhaps begin by asking all of you a question. What does effective enforcement mean to you? Conceptually abstract, but also on the ground. What is it that you think is best? What is it that we have? And where could we go with it? So maybe I will start with you, Max, following the order of introduction.
Yeah, thanks a lot. First of all, thanks a lot for having this conference, because I think it's a topic that is probably the most important topic. Real quick for us as noyb, I think by now we do 90% procedural stuff and 10% material law, and that kind of shows where the issues lie in enforcement. On the effective question, I think I would personally define it to say if the default is compliance with the law. If we go out in the world and venture and open an app and the default is it's GDPR compliant, and it's not a feature, but it's normal, I think that would be the aim for effective enforcement. And to get there, it kind of has to pay off to comply. I think right now it pays off not to comply. I'm mainly at business conferences, and most business people tell you, I don't get my boss to invest into privacy because the reality is to find it's hardly happening, so low, very unlikely to happen, and it just costs money to do that, so why should we? And I think that world needs to change, that culture needs to change somehow. And that would probably get us to a solution. It doesn't mean that we're going to have 100% compliance. There's also murder in life, even though there is like police being after it. But that we say, okay, that's a couple of percent that go wrong, but the majority is that we comply. I think that would be my definition. If I could add one sentence to that, I think one big issue is that in the privacy world, we have to look at, there is in German Rechtssoziologie or sociology of law, I checked that before. In English, there is a lot of these concepts exist, like why do people comply with laws, how do you enforce laws, all of that was talked about 100 times for 100 years in criminal law, in all other areas of law, consumer rights. And I think we probably have to learn from that a lot as well, what worked in other fields and what didn't. And that may be a probably more important part to look at than just what happened in the privacy bubble so far.
Thank you. Mr. Kelber, you're a data protection authority. Can you tell us your views and also touching on this culture of compliance? Is it something that we have?
Yeah, thank you. And first of all, thank you to the EDPS for hosting this conference and to speak in an open environment about what is with enforcement and other rooms for improvement. We had that debate, and we still have that debate among us as DPAs, but it's good to have that on an open forum too at that point. So the question of compliance and enforcement is a key issue, not only to the GDPR, but to every law. And this idea of that the complying to the rules of law and the monitoring and enforcement is fundamental for the rule of law and fundamental for the understanding of such rules for the functioning of sectors of our society. With the principle of accountability, the GDPR gives a much space for that idea. In that system, the first thing is, I think there's a different awareness of that fundamental rights by citizens, by authorities, by lawmakers, and even by companies. But as in other parts of our society, there is, even if there is a culture of compliance, there is still room to monitor and to enforce, especially because some of the violations of that fundamental rights are not visible at first. So secret tracking or things like that is not so obvious, like crossing at red light or something else. So this monitoring and enforcement is in the center. And I think compliance and enforcement are so two sides of a coin.
Thank you for that. What a beautiful expression to finish those remarks on. Paul, I'll turn to you now. What are your thoughts on this?
Effective enforcement, I think it is maybe not the right starting point. The right starting point, I would say, is that we want to shape our societies through democracy. And if a democracy adopts a law, then afterwards this law should be given effect. It should make a difference. That's the assumption. And I would think, the law addresses itself to people and companies. And in the real world, if we talk about this today, it's digital tech companies which are the key players, which need to develop an ethic of compliance. They really have to change tech. We have to get out of this, it's legitimate to be a black box. It's legitimate to lie about things. So I think we need to involve much more the tech community and not only hold them responsible, but also how we educate programmers and people who build these algorithms and these systems which collect data and which use them to profile people. And there, of course, the enforcement bodies have a key role. I would say it very simply, like in other areas of law, EU law, it's actually spelled out in fisheries and other areas. The factor between the likelihood of being caught not complying times the size of the fine which you get once you're caught must be high enough to really motivate also the rogue players, those who don't want to play ball, those who want to make money and don't care for the law and the fundamental right. And I think that is a responsibility of the DPAs to go for it. And I think GDPR gives the instruments to make it work. And I think we still have quite some scope upwards. I see a positive tendency among DPAs, but there is scope upwards to do a better job.
Thank you for that. Ursula, I turn to you now. You lead work in consumer protection. How does effective enforcement look to you? What does it mean to you?
Well, thank you, and thank you really to the EDPS for making this a big discussion, because it is overdue, I think, this discussion about enforcement and effective enforcement in the digital world. I mean, you think it's a no-brainer question, really. What does effective enforcement mean? Do we need a culture of compliance? Because what it means, obviously, is that the legislative objectives, that they materialize, that they become reality, and in the field of fundamental rights in which we are here, of course, there must be a reality for people, so that indeed they can protect their privacy, they are protected by design and by default, and that they control their personal data. And if that is not the case, and I would claim it is not the case today, at least if we look at the most important players, namely the big tech companies today, there is no credibility of the legislation. People understand that it doesn't work, and that means, and that is really the bigger scene behind, it is no credibility in our institutions, and it is no credibility finally, and that is a real worry nowadays in how our democracies functions and what people can do in their daily lives and how they can also live in a democracy. So currently, I'm afraid to say there is no effective enforcement. I would say we live in a world of commercial surveillance. I'm very happy that you also have Susanna Schuboff later in this conference, because I think she, with her work, she really was an eye-opener to many of us, and I think we're still at the point where there is an increase in commercial surveillance, and so we need to have this discussion. Let me also maybe make two small points. I think there is a lot of different elements when it comes to define what is effective enforcement, but in the context of this discussion and in the digital world in particular, I think we need to have strong European solutions where we want to enforce effectively. And let me say that I think in theory the GDPR is a very innovative and could be a really powerful tool. Unfortunately, it just has not delivered, and it has not at all, I think, met the expectations. And the final point I would like to make is that people, what we see from the daily work of our organizations on the ground, in touch with consumers, from their research, the effect of all this is that people resign. They just give up. And they know that there is something wrong, that it's creepy, that they don't want to give away their data, but they don't see how to do it. Policies are not comprehensible, it's not clear, as Mr. Kelber said, a lot is hidden. So people understand there is something wrong, but they give up, and that's not the society that we want to live in. Thank you.
Thank you. There's quite a lot to unpack in those opening remarks. Maybe let me start with the first point I think that Mr. Kelber and you, Mr. Schrems, touched upon, which is this notion of enforcement versus compliance, same side of the coin, or perhaps different. So, Max, question to you. Your NGO in Vienna submits literally hundreds of complaints. What is it that you want but don't have compliance-wise? What is it that you're looking for that's missing?
I think, and I'm really the boring lawyer, and I also, because the opening remarks were probably very aspiring that we had right now, but the reality on the ground is just procedural details, and that's not sexy. No one wants to talk about it. It doesn't get you headlines, but the reality is, for example, we have a case filed in Austria where we're a party. The Swedish say you're not a party, so the Austrians send it to a black hole. We have a case where in one country you say you have access to the documents, and in the next country you don't have access to the documents. And literally, we're at a point where my own legal team, we literally have debates about filing stuff with DPAs anymore. We literally, my colleagues are like, why do we do this anymore? It's absolutely useless. And I know that a lot of people really tried their best, and I don't, I want to differentiate there, but the bottom line of the system is, for example, we have about 50 cross-border country cases. Not a single one has a decision yet. We have cases that are 4 or 5 years, and even between DPAs that speak the same language, that are willing to do stuff. So there's a lot of these kind of nitty-gritty details in the workings that just don't work. And there, I mean, probably would be a legal study now to kind of list them all. But I think that's oftentimes where we'd have to go in and have to get it done. The other thing is just also this topic of what you call general prevention, the general feeling that there is going to be a consequence if you breach the law. And that's literally what I hear at all the business conferences over a beer later is that feeling doesn't exist currently. There's the 1 or 2 headline penalties that are handed out so that we can say in the media, okay, we did 1 big penalty this year. But if you calculate it by the amount of controllers that are around, especially also smaller controllers, it just doesn't make sense. And I think what we have here is a negative spiral. And I had recently actually with the German DPAs a presentation. The first picture I had was a favela in Rio de Janeiro. It's just an area where you don't even try to enforce it anymore. And that becomes such a negative situation that it's really hard to regain territory there. And that's a bit what we did with the digital sphere. If companies learn that not answering an access request doesn't give you a result or doesn't have a consequence, you don't do it. Consequences, we have more and more complaints. So DPAs go under in the complaints because there's so much non-compliance, which again means you can't even work on all of them. And I think there's a certain spiral once there is this general, what Paul mentioned before as well, the moral and the ethics isn't there. Like we usually don't kill other people, not because there's the police, but we believe you shouldn't kill other people. In the privacy sector, the players we talk to don't believe in privacy usually. They are not morally and ethically convinced of this. So you need that enforcement, and I think that is these dynamics that we see right now after 4 years that make it really hard for everybody in this sphere to get anything done, even if you're really willing and you want to do your best as a DPA, which a lot of the DPAs obviously want to do. And I think that's a bit, I hope, answering the question.
No, thank you. Maybe then let's stick to the topic of DPAs for now and turn to the DPA. So, Mr. Kelber, are you satisfied with the level of enforcement from you and your colleagues? What more could be done by DPAs, both individually and collectively, given that cooperation, obviously, under the GDPR is such an important concept in order to get things moving?
We had some risk to see very different parts of the field. So my colleagues see the pathological cases which are not solved. And DPAs see the numberless things where they give guidance, where they have success in bringing accountable companies to change the way they process data, and the number of cases solved. So for example, in one of the letters of Max, he said, look at the Spanish DPA, how much fines they are producing every week. So there is success on that. The GDPR itself gives everything we need for effective enforcement and for compliance in theory and in the most parts of practice. So from all the supervisory authorities, investigation and remedial powers, significant fines, 4% of the global revenue. The implementation, there is some justified criticism, especially on some important cases, cross-border cases, which would be the base for other decisions to be made, and other decisions wait for the solving of that cases. But on the other side, there is a number, and an increasing number of cases solved at the national level, and even on the cross-border side. So with the cross-border authorities, we identified that there are still differences in the way how to handle cases of procedural law, of deadlines, of how to work with the complainers in such cases. And I think there would be 2 steps necessary to deal with that. The one side is the Commission itself. So the European Parliament in 2021 saw some of that problems and asked the Commissions to act as the guardians of the treaty, so to use the complementary measures which are included in Article 97 of the GDPR to identify, for example, natural obstacles. Everybody knows that in almost every country there are some obstacles. So to speak from the German perspective, you know, I'm sometimes cited to speak on other countries, but the German one, we have obstacles for really fining companies. Some of our courts said, no, German law says you can only fine persons, and I think that's could be an obstacle in some parts of really enforcing the GDPR. But the EDPB and the DPAs itself continues to strive to improve the enforcement situation. And we met in Vienna because we see that there are not enough output on the significant cross-border cases. And we identified some ways to handle that. The first one is we will try to identify the most strategic cases. And to try to focus our common resources on such strategic cases with binding timetables on that. And some of that strategic cases is on how deeply they impact on the fundamental rights of European citizens, how many other cases depends on the solving of that cases. So we need the resources, especially from the EDPB and its secretariats for that way. The other one is identifying such obstacles, differences in procedural laws and others for ourselves, but maybe as a blueprint for asking the Commission to step in. They do step in sometimes with infringements, like these days in Germany. Thank you for that. Very important for our work there. But to really level that. And I can, for example, imagine that we will have a set of rules, procedural laws for handling cases which are set on the European level and not on national level.
Interesting. Thank you for that. Maybe let's turn to the European Commission then. Mr. Nemitz, you were lead director when it came to the drafting of the GDPR. Clearly, enforcement was envisioned differently back then. What is it that you had envisioned? What do we have now? And what are your thoughts on the things that have been said today?
Well, I have to first disclose I'm a co-founder of noyb with Max, so I have a great sympathy for him. And also, I speak here a little bit also as an individual who's teaching. You have 3 commissioners, 2 vice presidents of the commission today. You will get the official view in the later speeches. So I will answer your question, as Paul Nemitz. And so I would say, first of all, the GDPR contains the elements which make it possible for Max and such organizations, and we need more of those, to give a dynamic into the system. And let's not fool ourselves. As we have heard, privacy and data protection is a fight. And fighting for the law, it's already something Savigny and others said, it has to be done. It's a struggle, and all players who want to make this law work must be ready to go into this fight. Which means that it's not enough to do conferencing, guidance, to ask others to do this or that, and to do talking and information. No, enforcement of law, fighting for the law means doing it. And so I'm actually not unhappy with how GDPR is developing. I think we have to learn from each other's experience. As Ulrich Kelber said, I think in every member state, there will be issues, but let me take up the issue that some court or some administration in Germany says under German law you cannot fine, although GDPR foresees clearly fining. Well, the fight is very simple. Of course one can refer to the Commission, but the Commission has a policy of not bringing infringement procedures in cases where there are independent bodies. We don't bring infringement procedures because a court is doing something wrong, because what is the government to do? The government cannot instruct the court, and we have the same problem with with DPAs. So, to make it simple, in such a case, a DPA just has to set aside and ignore what some court has said and just bring another case and fine on the basis of GDPR. And this will become a court case, and if things work right, this case will go to the European Court of Justice, because this poses a key question of EU law. Namely, how to interpret the GDPR and what does the primacy of EU law over national law mean. This is a typical case for me where a DPA who has the resolve and is ready to say, well, it may well be that one court said you cannot fine, but, well, we'll bring another case, we'll fine again until a national court does what it should do in this situation, namely present the question to the European Court of Justice. So I think if we want to make GDPR more operational, we have to use the classic instruments of enforcement discussion, which are around in many other areas of law. We have to be more rigorous, for example, on the questions of burden of proof. Who has to prove what before the DPA? I think the DPAs are just too shy. It is the controllers and processors who have to prove compliance and not the other way around. And I can just say, you know, guys, go for it. Deadlines have to be set in different directions. If you ask for information from a company, don't just talk or send a letter without a deadline. No, make a formal decision requiring them to give you information in a certain deadline. If the formal decision of a DPA is not complied with, you can fine them immediately for not complying with your information request decision. You know, this type of technique needs to be developed. It is possible under GDPR, and I would say this. I see a positive tendency. I thought many things what Ulrich Kelber said were very good. There are many more issues we need detailed discussions about. Let's look at how competition law has developed. It has taken time. I think GDPR will not need the same time as competition law has had to develop all these procedural nitty-gritty things. Very late in the day only did we, let's say, harmonize competition law more than it was in the treaty in the beginning. It was a very general norm, and enforcement was moving forward. So I would say calling at this stage already for new law, that's much too early. I mean, I would say, come on, guys. For example, if you have a problem in national procedural law, there's a very simple general rule of EU law. National procedural law either must give effect to EU law or it must be set aside. You simply have to ignore it and give effect to the EU law, which is higher. So, you know, maybe the DPAs have to do two things, if I may. Be a little bit more rigorous in applying general principles of EU law on primacy. And second, bring in people which have the knowledge, but also the willingness and the character and the experience of hardcore fighting enforcement. Bring in, you know, the deputy head of the Public Prosecution Service. Bring in the deputy head of the Competition Authority who has already shown that she or he has teeth. And, you know, I would say to politics, appoint such people as head of DPAs. And if someone has been appointed who doesn't have this grit and this experience of doing litigation and going the hard way, then my advice would be get a deputy who has it and get fighting.
Okay, well, Mr. Nemitz, thank you again a lot to unpack there. And I do want to give the panelists also an opportunity to react to some of the things that you said. But before that, I do want to turn to Ms. Pachl because, Mr. Nemitz, you spoke about competition law and the enforcement governance model there. Ms. Pachl, tell us about consumer protection. Tell us what's working there and what is the interplay with data protection? And is there anything that we can stand to gain?
Yeah, thank you. I mean, consumer protection is a very diffuse field, right? You do consumer protection through various areas of law. But in the narrow sense of the consumer law and the consumer law enforcement, we have a regulation which is relatively new. I mean, it has been changed to allow for more cooperation between national consumer authorities. But I have to say, it is not very clear at this stage whether this is going to be successful or not, because it has been in place only since 2 years, as I said. We have two really important cases that we brought, and that's already an interesting point. European organizations like we are, they can bring cases, they can bring complaints, but differently from the GDPR, there is no obligation of the national authorities or of the network to react. So this is a major flaw, but just to say it's a good point that European organizations can bring complaints. And then the authorities can make a common position. But the enforcement itself really still lies on the national enforcers. So if that, common position is not respected by the trader, each and every single authority would have to enforce. And I think that is going to be very hard. We haven't seen it. But again, the GDPR has a big advantage in that there is one decision that is then valid across the European Union. But if I think we would try to learn from other areas of law. It was mentioned, I think, competition law is, of course, the most advanced, and it's, of course, a different structure. It's a shared competence between the European Commission and the national authorities. But maybe one single point I would like to highlight. What is, I think, really the key problem in the cross-border cases, as we know in the GDPR, is the forum shopping. So we have a structure where the choice of the forum is made by the infringer. And the choice of the forum should not be made by the infringer. It should be made by the legislator, or it should be made by the enforcers. And the competition law and the consumer law, they have this advantage that they don't have this country of origin principle as the guiding line. And country of origin, where you have the authority of the trader in the lead, is a concept that comes from the single market. So it's a trade principle, so to speak. It's not adequate for enforcement. So I think this is, if I may say, this is a weakness. Now, how to overcome that? I've heard Mr. Kelber talking about the Vienna Declaration, and I think that is really a silver lining on the horizon. I'm looking forward to see how this is going to work out for strategic cases. Because currently I can only say from our own experience, and we all know that, but just to repeat, and I'm also glad to hear Pachl have all these great ideas of how we could do it differently and how the DPAs could, strategically advance, but it just doesn't happen so far. So it's great to see the declaration and the commitment, I understand, from the DPAs in the big cases to work together. We have, as BEUC, coordinated action by our member organizations. So just in brief, 7 organizations 3.5 years ago brought complaints to their national DPAs in different countries against Google for the tracking or the data processing of location data. And that, I would say, is definitely a strategic case, knowing about the sensitivity of location data and, of course, the size of Google. And we're still waiting. I mean, this is 3.5 years. Nothing has happened. Of course, the case is pending in Ireland. We have made a report about the experience we had that we published exactly 2 years ago. And now 99% of that report are still valid in the sense of nothing happened, except that the DPC gave a draft decision to Google 6 months ago. But we didn't hear anything of that. So we have made all the analysis of what does not function, and that starts from, as also Max has mentioned, the admissibility of qualified entities. And here we really miss a mechanism of mutual recognition. So if you're in one country, you can, in the collective interest, bring cases. You should be allowed to do that in other countries, like in Ireland, for example. Ireland doesn't accept that, so you can't do that. You have to bring an individual case on a data subject. We have, of course, procedural issues. If you go to Ireland, you depend on Irish procedural law, and that is very complicated and very costly. We wanted to go against DPC for taking the decision to do an own volition inquiry instead of looking into our complaints. Because they decided own volition, that's the way forward. We said, okay, we want to challenge that decision. We would need to go to the High Court in Ireland. Impossible. I mean, it's extremely expensive, and the risk to carry for an NGO is just not feasible.
We did it 100,000 euros. However, now the DPC is paying us because they lost it.
That's what you could do.
Yeah, but no average person is going to do that.
That's the problem.
Yeah,
so
but
I'm just making all these examples to say, yes, indeed, there is a lot of obstacles, but looking at the administrative, the procedural side, as Max said, as I hear the DPAs also discussed, and looking at taking up strategic cases jointly, I think that is really the way forward.
No, thank you for that. And here I want to turn actually to Mr. Kelber to give
for
you the
a reaction
opportunity.
on Paul, please. So thank you for the examples which had nothing to do with the teeth of DPAs, which cannot be brought to the ECG. So obstacles which are really even an obstacle for every DPA who wants to react on things. And we did our homework, so naturally every letter to a company has a deadline. And if they are not fulfilling the deadline, they will be fined for that. The right to be heard is one round with a deadline of it. And we bring cases to the courts where we think that there is a contradiction between national law and European law. At the example I've said, I've won my cases, but some of my German colleagues lost, or the Austrian colleagues lost. And it's not on infringement procedure on independent authorities, but if there's a real contradiction between national law and European law, I think it's the task of the European Commission to step in, maybe first with a dialogue and not with an infringement process. To really have that improvement, we need to act both, the DPAs and the Commission. I think there's more than enough room in the existing system to adapt that is faster than every real renovation of the process. But we really have to look on that and to have a comparison with the antitrust, with the competition law. So there was a reason, I don't know if it was a good reason, to have a different enforcement in the data protection area than in the competition area. So, for example, when I met with my colleague of the competition authority, which is just 1 kilometer away in Bonn, it was our both opinion that it's better for the competition authority to go after Facebook, because I cannot go directly against Facebook. I did that now with the fan pages. I went to a public authority, so to the federal government, and told them, you must not use fan pages anymore. It's unlawful. My colleague from the antitrust or competition authority, he can go directly to Facebook and say, what you do with the combination of data from different sources is unlawful. So if you gave us different ways of how to enforce, you must have a look on it as a commission, how it can be used, and what's the role of the commission to just fortify the position of DPA. So that was a little bit too easy. Both sides have to act to be really successful on that important, strategic, cross-border cases. These are the problems. The cross-border cases, strategic ones, not the work at the national level, but this cooperation. I think if we fulfill the things we said in Vienna, we will have a step forward. But yes, we ask the Commission to step in at that position and not trying to centralize the whole process, but really giving some room to that national obstacles.
So you speak about national obstacles, and you speak a lot about procedural obstacles as well in terms of differences in complaints handling or things as such. I want to turn again to the people on the ground really quickly. What are your views on this?
Just to probably combine what Paul has said and Mr. Kelber has said, I think both is true. Like, the reality is that these courts should get it right, but we have it in every case again and again, be it civil or administrative, that judges also have a cultural issue with the GDPR. They kind of try to get the cases somehow out of the place it sometimes feels. And there is basic stuff like that. We literally now, last week we talked about Sweden not giving you the right to be a party. We don't even find a law firm in Sweden that wants to represent us. And the cases that exist in the law, in the courts are, no, you're not a party. Now, you can fight all of that through in each member state, which hundreds of court cases, and it's all the basic principles of the GDPR and of European law. The reality is, this is going to take us 10 or 20 years to fight it through. And that's probably a bit late for the promise that we had for the GDPR. So I do sympathize with the problem that Article 60 has that basic problem that it just tells the DPAs, you guys work together. But we don't have any other area where in administrative law we have authorities actually working together in a team, having joint transnational procedures. And again, even willing DPAs, and I also have to add, because so far it was very nice, there are also unwilling DPAs that try to find these problems. But even the willing ones find these issues in their national procedure, and it's really hard to overcome, because the national courts will feel like, how can you do that based on some principle of European law, because here it explicitly says A, and you didn't do that. And that also gets us to a broader problem that connects to the forum issue. The idea of the GDPR was there is an LSA, there's a lead authority, but you're going to jointly work together. The reality is most DPAs just hit the forward button, it goes to the LSA, and you never hear of the case again. So this whole actual culture of working together, having a call, doing a joint operation, it just on the ground doesn't happen. So oftentimes we most of the time have to go to the LSA directly, figure out after 2 or 3 years what happened to the case. Oftentimes the case didn't arrive there. We have masses, but a good amount of cases that just never arrived at the LSA, and we found out 2 years later that it just never got there. And that is exactly where the average person is going to have a really, really hard time unless we have clear regulations. The guidelines, I think the Article 60 guidelines were great, but I think we need that in law, because any national court will be like, that's nice guidelines, but that doesn't override my national law. And I think unless there's clear and objective regulation below the GDPR, maybe a procedural regulation that kind of clarifies that stuff, that may do the trick. One last thing that I also want to mention, because it's something I feel strongly about. The significant cases idea is great for the general deterrence and all of that, but we also just have the average Joe that just wants to have access to his data. And these cases also take years and years, and that is a fundamental right. It's even in Article 8 of the Charter. And we hear DPA saying we're only going to do significant cases anymore, and any individual access request is by definition not a significant case. So again, people just have rights on papers and they don't get it. And a lot of the frustration, we literally get an email. If you go on Twitter, you're like, these DPAs are useless. I made this access request. I never got an answer. There's never any consequence. And we also have to think how we can get these individual cases up and running, which is even much more nitty-grittier than the big topics where probably everybody agrees, because it's really this kind of annoying, boring cases of someone just want to have access somewhere, but it's also a right that people have and that they somehow have to get. And we usually have great access as an NGO compared to an average person, and we know what to do, but the average guy also has to somehow get there. And now you kind of gender all of the guys that I had in the last intervention to cover that as well. I think that is probably a part to do. One very last sentence, because I just realized I mentioned that, the fighting part you mentioned. That is also something that we need in the culture. We have, for example, if you have an access request, we have people sending back and forth what they think it's on the database. It's absolutely useless. You have to do an on-premises investigation, walk in there, check what the database is, then you can say, was there full access or not? And a lot of that, when we apply for an on-premises investigation, the DPAs are like, oh, never done that in our life, totally new. But how would you investigate a case like that other than with it? And you're absolutely right, that's in the GDPR. It explicitly says you can do an on-premises investigation. It just, in the reality, never happens. And I think that's all the tools that in other areas of law we see every day. But in our cases, we literally are laughed at of the idea of actually doing an on-premises investigation and access request. And these tools need to be used at some point.
Speaking of tools very quickly, maybe here, Ms. Pachl, I turn to you. And, BEUC has mentioned that there's different ways to approach potentially reaching enforcement. You can come from different facets. Now, with the upcoming consumer redress and also with all of the CJAU cases that are allowing, collective actions to be brought, do we need one route to effective enforcement? Do we need multiple? What are your views?
Yeah, thank you for that question, because it's a really important one. Definitely, it's a good thing to have multiple routes, because this also allows what we call an integrated approach to enforcement, and this is something which has been a bit missing, I think, in the current discussion, also particularly in the field of GDPR. So what I'm saying is we need public enforcement, we need public authorities to act, but we also need private enforcement. Private enforcement meaning enforcement to do injunctions, to stop unfair behavior, or, and that is the key issue here, to do redress claims. And so this is something which is new, which has come now in the form of the Representative Actions Directive that will be applicable in 1 year already. So the member states are currently transposing it, and it will give qualified entities that have to be recognized as qualified entities by the member states, consumer organizations, civil rights organizations. It will give them the right to compensation, to collectively ask for compensation, so group actions, so to speak, class actions if you want. And it will also include actions based on the GDPR. Currently, we don't have that option to group together under the GDPR to ask for compensation. So this is a real step forward. I think it will be very important. But again, I come back to the point on procedures, because there is a link, because it will really now depend how successful that new tool can be, on how the member states will use it and implement the directive when it comes to the procedures. So there will be questions like, do you need an opt-in procedure where every single consumer have to say, I want to join that action? Or can we rely on opt-out, so where consumers are automatically, those who are affected, automatically in the group, and you don't need to reach out to everybody and collect everybody. So there is a lot of, there is a lot of other questions related to the procedural costs, etc., that will be essential to see whether civil society can really make use of this new tool. But it will be important for the GDPR, and hopefully will be important also in terms of its deterrent effect on the market, and is definitely a complementary element that so far we haven't had in the field of GDPR. So I'm really looking forward to see how that's going to work, but we will need the governments to make sure that they make a user-friendly, civil society-friendly transposition of that directive.
Mr. Nemitz, I turn to you here. We've heard a lot about needing a deterrent effect. We've heard that there's different approaches to enforcement coming together. Obviously, the Commission has a role to play in all of this. How do you see the future? What's the benchmark in compliance for 1 to 5 years? And what more can be done in the current system to encourage systemic enforcement?
Yeah, I would say that the main debate is here not first between the DPAs and the Commission. We have a piece of law here which has been put in place by the European Parliament and the Council of Ministers. With democratic legitimacy, and institutions have been created in the treaty directly, and then their powers have been defined in the GDPR. And so I think it's just not good enough to say, we can't do our job properly. The democratic bodies have decided this is, for the time being, what it is, and it is the duty of the institutions which have been created for this purpose, namely the DPAs, to make it work. And that means, I can just say, go for it. There is still scope. Now, every professor constantly asks for new law. I know it better, this law is no good, need new law. But that's not how democracy works. Democracy means there is a law and it has to be made to work. It has a purpose, and institutions are there and they have to do their job, and they are now the first port of call. Now, it is true in competition law, after decades and decades and decades of optimization, more detailed rules have been made, but they have worked on the basis of a few articles in the treaty. We already have a regulation which is pretty detailed and pretty long. So I would say for the time being, nobody can relax in enforcement by saying, well, actually, we would need another piece of legislation. That's just not good enough. And I see an upward trend, and I think, much more can be done. And, just to take this example, if somebody goes to a DPA and says, there's a company which doesn't tell me what data they have, and there's no access request granted, or they constantly ask me questions back, or they just don't delete. These are cases which should be dealt with like this, with an order from the DPA. One time asked, of course, right to be heard, but very quickly, because these are simple things. And I would also say the great progress which we should not just now put aside between the directive and the regulation is that the regulation gives an individual right to citizens to have a follow-up from the DPA. So it is important that DPAs who don't do their job are taken to court too, because this is what the DPAs also have to learn. They don't only come before the court if they take a hard decision against a processor. They also come before the court if they don't act on complaints. And so I would encourage people to increase that side of the pressure. That's very important, that DPAs understand it's not a way out in terms of workload and so on, just not to follow up complaints and we're going to do other things. Those times under GDPR are over. So if you ask me in 10 or 20 years from now, what I would hope is that we have much more organizations like that of Max in every member state, that there are more people who are ready to go for it. If they see a DPA is not doing their job, take them to court, make them work. And this debate, of course, then also has to find a reflection in the political area. If a DPA is taken to court often, maybe because it doesn't have enough resources to do its work, this gives additional arguments to the DPAs in the political area, in parliaments, in national parliaments, to say, look, we have a very heavy litigation load. We are being taken to court both by those where we take hard decisions, but also by the citizens. We just need more people, and we need more resources. So, I'm sorry to say, but I think the political reality is, if DPAs don't feel the heat from citizens and from NGOs, the whole political dynamic, which will then also lead to getting more resources and maybe changing national procedural rules, which are obstacles, will not work. So I would think this is a matter of engagement, and fighting for the law is not only a matter for the DPAs, it's also individuals and NGOs who fight for their individual human and fundamental right, which makes this system work.
Mr. Nemitz, I'll stop you there because we do have a lot of people in the room, and in the spirit of democracy, I do want to open up the floor to a public Q&A. But before that, I want to give the speakers 30 seconds. Any reactions? If not, we'll come back to you at the very end.
I would do a really quick one. I think what we have, and maybe that's my aspiring ask for the whole conference, we're right now here in OR. Like the DPAs should do it, or the Commission could do a new law, or the NGOs should go ahead and give heed to the DPAs. And I'm sick and tired of everybody pointing at each other. So I think for everybody, the question is, can we do an end? Can we do that more, here more, and so on? And a lot of that is theoretical in the way, for example, for us, I can tell you, if we go to court, the only country it's cheap is Austria. It's 30 euros to go to the court. In all other countries, it's about 5,000 euros minimum to bring a DPA to the court. So you have a free right to a complaint, but if that free complaint isn't dealt with, you pay 5,000 euros. And if you're in Ireland, you pay 100,000 euros. So the idea of BEUC cannot afford to go to court on that in Ireland, being a large organization. So an average guy is not going to cut it. And I think my solemn ask for everybody in this conference is, how can we think how we can solve all of these issues at the same time, instead of saying the other one should do it? And I think that's a bit what we had on this panel a bit.
Thank you, Mr. Schrems, Mr. Ulrich.
So Max is right. I told you what we are planning to do with the Vienna Statement and fulfilling of that. But the reality on the ground is, I have colleagues with a number of 13 people working for them, for all the national work and to follow all the European discussions. So it's a question of resources of the national DPAs. I'm one of that, I have to hire people and I have the resources to hire them, and of the EDPB. Then things like the support pool of experts, identifying strategic cases, joint work on that, is a question of resources. And there's a gap between some of that resources used in other cases and at the European level, the intervention on disturbing national laws here and in other parts of the things. And we will point on that, but we see what is our own obligation to work on.
Can I just quickly also react, because I think it really needs to be underlined. So it's exactly what we want, to fight for the rights and for the fundamental rights of people as an NGO. But I can only say from across Europe, what we see regarding our membership, that the support of NGOs, the support to civil society, being active, being well-resourced, is declining in the member states, and particularly worrying in the eastern member states. So I think we also need to see what type of role do we expect from civil society, and if we give them the tools. And let me also make this point, because I'm very happy about the theme of the conference, because it's not only GDPR, it's in the digital world enforcement. And what we see currently is really interesting, and this is so timely, this discussion. We see a big enforcement discussion in the AI Act. We see a big enforcement discussion, or we have seen it in the DSA, we have the DMA. But the Commission proposals were not, except maybe for the DSA, but in the AI Act, for example, there is no role for civil society. There is no representative action directive included in that, so that civil society could become active if AI systems do not deliver, if they damage people. That's just not foreseen. It's not comprehensible to me why the Commission does not approach in this integrated enforcement idea and really make sure that public and private enforcement can work together, because otherwise there is nothing that civil society can do. And definitely the resources and the support need to be given, not only the tools. Thank you.
Thank you. Mr. Nemitz, do you want the floor for just 30 seconds, or can I open it up to the public?
Well, I think, we are now in the Future of Europe conference follow-up discussion. My personal proposal is the Commission needs a democracy mainstreaming program which exactly looks at every piece of legislation and asks the question, can we, in this piece of legislation, and it can be in any sector, now you took AI, it could be in transport, anywhere, yeah. Can we, in our legislative process, in the proposal, enlarge the scope of participation of citizens and therefore inspire the scope of citizens' participation and democracy also when the law is being in the stage of implementation. I think it's true that, we have now a democracy action plan. The Commission, I think we have understood that we have to invest much more in democracy in Europe, and this is happening. But I would say in our system of impact assessment, this question is not being asked so far. And now, this is my personal view, I have published this. I think there we can get better. The impact assessment was invented in times of neoliberalism, the cost of legislation, it all costs so much to companies and so on. Fine. But the times have moved on, and the new challenge to give tools to civil society to make law and democracy work should find its way into the impact assessment rules of the European Commission.
Thank you very much, Mr. Nemitz. Guys, we have a couple of minutes. I hope to take 1 or 2 questions from the audience. I think we have some mics on either side of the stage, so if there's anyone, please raise your hand and we will send the mic over. I think we have one over there and one in the front. Let's start with perhaps over there. Yes.
In the dark.
Thank you. Alan Rawl, Sidley Austin. It was a fascinating panel, really very interesting observations. I'd like to start with, Mr. Schrems made I think, a critical point about there not seeming to be a moral and ethical impetus to compliance with the Gdpr. Mr. Nemitz, I think, talked about perhaps a lack of or insufficient intensity on the part of some data protection authorities, and Ms. Pachl talked about declining interest in civil society, perhaps. I think some examination or introspection on the reasons for that would be warranted. Is it possible that the GDPR itself, or that the approach to enforcement and compliance with GDPR either is or has become too bureaucratic, and that, for example, the poster child of the significance of GDPR has been the cookie banners, which are in front of people all the time and seem to be more of a nuisance than representative of an underlying fundamental right. So is it possible that the fundamental right of privacy has actually been diminished or demeaned by the bureaucratic approach, the excessively administrative approach, perhaps, to the fundamental right of privacy and data protection, rather than a focus on what actually harms individuals? Is it the case that citizens themselves are as intensely focused on this right, or does their behavior and their apparent declining interest, does that reflect that the fundamental right has not been satisfactorily conveyed to them through the actions of the institutions themselves?
Thank you very much. Maybe what I'll do is I'll take the second question from the front and then hand the floor over to you guys.
Thank you. My name is Simon Hania. I'm your DPO at Uber, and I have a very simple question. Please point at where DPOs can be part of the solution. Can you reflect on that for me, please?
Speakers, over to you. I ask that you keep the interventions short and sweet.
If I may quickly on the colleague from Sidley Austin, probably there's some background for the question. If you would have been here when the GDPR was negotiated, everybody from the privacy bubble was not caring about the bureaucratic parts of the GDPR. That was coming from industry. The idea was we're not going to comply with hard lines, but we're going to do some impact assessment internally and produce some paper instead of actually doing proper privacy protections. I don't think that comes from the privacy community. I think that comes very much from the community that you represent.
Yeah, yeah. I would also say, I heard here the people are not interested in this right anymore. I mean, in America and in Europe, the empirics are totally the same. People don't want to be snooped on. Also not in America, neither by big corporate nor by the state. What Mrs. Pachl said was that the space for civil society in autocratic countries is being shrinking, and they are being put under pressure, and that's why engagement is going down. But it doesn't mean that people are not interested in. So please, let's keep our democracy vibrant, and let's not go around and preach disengagement and tell people, oh, nobody's interested anymore, and therefore you should also not be interested. This is American lobbying of its finest type, and I must say I have no sympathy for it. On the question of the DPO, this is a very good question. The reason why the DPO has such a strong position in GDPR in terms of independence and protection, which also has labor law implications, is exactly this, that a DPO must be able to bring the unwanted truth to the management of the company, which is, how you are earning money right now is not in line with the law. So I would say the DPO, who has visibly for the management excellent relations to the DPA and is seen together with the DPAs and, not as a lobbyist for going down, but as a viable partner of making this law work, is the most effective DPA. You see also for lawyers, if I may say, because the question was from a lawyer. There are two types of lawyers, and by the way, two types of education of lawyers. One type of education of lawyers says to the law student, you are an institution of the law. Your job is to make the law work. The other type of education and also type of lawyer is the lawyer whose job is to only represent clients' interests. And if clients don't want to comply or are not interested in the law, the lawyer becomes a lobbyist. And I think this is a choice which DPOs also can make. And the good thing is, if they want to be the hard DPOs, they can be hard DPOs because the GDPR contains, I think, good protections for them.
Thank you, Mr. Nemitz. Over to you both quickly.
I can just maybe really clarify, and thank you, Paul, because that's not what I said. I said that people resign because they just don't see how they can manage to protect their rights, and I don't want to be misunderstood, right? That doesn't mean that people don't care. From all the work that we see, from all the surveys we see, people are not at ease. They know that it's not right, and they care about it. It's just that they don't see how they can fight back, if you want. So I just don't want to be misunderstood. Yep. Thank you.
Second question, yes, there's a long tradition, especially in Germany with DPOs, and we invest a lot of time in the dialogue with the DPOs, sharing all information we have with authorities and companies with the DPOs, and every control of an authority or a company, we include a close look on the independence and the resources for the DPO, and press the, if we are not satisfied, we don't see it in complying with the law to give more resources and more independence. Second one, we have to watch ourselves very carefully every time if we are too bureaucratic or not. And sometimes we work on, can we really solve things with a letter instead of that formal process, but cookie banner is not a good example. So a well-programmed and fair website does not need a cookie banner. First. Second, and there's more to do, is really ban all dark patterns. So if you really have one click to reject them all, it's quite fine. And the third one, it would have been the companies not following international standards that you one time said, I do not want that kind of espionage cookies on my computer. So don't ask me, I will reject it, do it automatically. So it could be easy to get rid of that cookie banners, but that's the job of the violators of the GDPR and not of the guardians.
Guys, thank you very much. I think what becomes clear from this discussion is that there's a lot to discuss when it comes to effective enforcement, whether it be individual, collective, coming from industry, coming from the people. It's obviously a narrative that must continue in different forms and facets in order for us to come up with some sort of solution in which, as Max said, I think as most of you said, in which we can work together, in which we can combine our forces and think stronger together in order to be able to give the right to data protection the actual realization that it deserves. For now, please join me in thanking the panelists once more for their contributions.
Das war gut.